My name is Rob Frazer. I'm a partner at Goranson, Bain, Ausley here in Austin, Texas, and I'm board certified by the Texas Board of Legal Specialization in Family Law. I'm going to talk today about the common or typical path of a family law case that involves children and talk to you a little bit about how it typically goes. So every divorce case with children, without children, is very, very unique. It's part of what I love about what I do. I have seen a theme or a common course over my 13 years of practice that I want to share with you here today. At the start of a divorce case with children, as you can imagine, emotions are typically very high. Typically, we have parties separated and arguing about rights, duties, and possession and access regarding the children. Though we at Goranson, Bain, Ausley always want to try and reach an agreement without going to court, sometimes those emotions are so raw and the parties are so far apart, it might be necessary to participate in a temporary orders hearing. It is common that at the start of the case, the people have a lot of emotions, they have resources, and they want their day in court. And we at Goranson, Bain, Ausley are skilled and experienced in advocating for our clients at those temporary orders hearings. However, at the temporary orders hearings, it's not uncommon for the parties to be somewhat dissatisfied, not with the outcome, but with the process in general. It's a very unique circumstance that we have that parties who once loved each other, swore that they would live together in harmony through sickness and health, for richer or for poorer, then find themselves at the courthouse saying bad things about one another, knowing the whole time the immediate fate of their children hangs in the balance with a stranger, a judge that they don't know. After that temporary orders hearing, it can have the effect of resolving some of the disputes between the parties, which is a very positive thing. But I've also found that after that taste of court, with the expense, the emotional turmoil that goes with it, and the judge clearing up some of the ambiguities between the parties, the rest of the case takes a far different approach where the parties are more amicable and understand now that that issue has been resolved, they can work towards avoiding a second, perhaps third trip to the court and instead focus on resolution through the informal settlement process, mediation, and then ultimately, and only if necessary, final litigation. My advice for people to avoid court, particularly even temporary orders hearings, is to be reasonable, to work with an attorney that's not overly aggressive, who's solution-oriented, to reach out to opposing counsel and try to find some common ground and some solutions that prevent the parties from going to court and litigating with one another, instead looking towards the ultimate resolution of the case. Sometimes necessary to put some temporary orders in place to manage rules about what are we doing for school for the children, what are we doing for finances for the parties. But if an agreement can be reached early in the family law process, it is a great indication that the parties will be able to reach an amicable solution in the ultimate resolution of the matter. Ideally, parties who love their children can put away some animosity that they have between one another. They can work with good attorneys to come up with a solution to reach an agreement, even on temporary orders, to put in some rules in place for the children to maintain the calm, the peace, and establish dignity in this process as they reach an ultimate resolution.